what I want to look at in this few moments that we have, we're doing so much, we could be here for hours, but what I want to look at, three main areas that we want to look at. One is to look at what's been happening in Westminster, what UK Parliament, the UK government working through the UK Parliament, what the UK government has been doing to prepare the UK legal order for withdrawal. And we've heard from Rachel about what's happening between the UK and the EU and the prospects for a deal or no deal. Whatever happens there, whether there's a deal, whether there's an agreement or not, things have to change here. Things have to change in the UK. Changes have to be made to our statute book, to our laws, to make sure that things work once we leave. So that legislation has to be put in place, whatever happens, whether there's a deal or not. So we're going to have a look at that process there. We're also going to have a look, the second, what's been happening here in Wales and also in Scotland. I will sidestep Northern Ireland. I will just make that clear. If you're saying she's going to say something really interesting about Northern Ireland, no, I'm not. Okay, what I would say about Northern Ireland is if you want to follow up any of the issues, critical issues around the Northern Ireland situation, Katie Hayward, we will tweet things out about this. Katie Hayward at Queen's University Belfast is just superb on this stuff and is able to convey critical issues in an incredibly engaging and a very effective way. So I defer to Katie. There we go. Okay. So we have Westminster. We'll have a look at the devolved level and the activities that have been taking place then in an attempt to respond to what's happening in Westminster. And then looking prospectively forward a little in terms of how might Westminster and Wales and Scotland, and Northern Ireland, if it ever does get itself back up and running again, how are these going to work together after we've left the European Union? Okay. So, Westminster legislation. This time last year, sat here and there was a picture of the Queen with her blue hat on with the yellow flowers. It looked like an EU flag. And she was introducing the bill, what is now the European Union Withdrawal Act, that has now received royal assent. And it's taken sort of a year to come through the legal process, to work its way through the House of Commons, the House of Lords, to go back to the House of Commons. It had a battering. The government really did have a battering getting this piece of legislation through. But in essence, the legislation that we've got at the end, it's been improved in some respects, but it's still pretty much doing the same sorts of things that it was introduced to do. And in terms of what it does do, it does three key things. First off, and although it's now law, some bits of it don't take effect yet. Okay, so first off, this hasn't taken effect yet, but it will repeal a piece of UK law, the European Communities Act 1972. And that's the doorway through for EU law into our legal order. And what that will do at exit day, so that because these things may then have to be amended, but it will turn off the European Communities Act 1972. And so then EU law doesn't have roots in our national legal order anymore. That's been removed. So what we then need to do is secure that existing law in some way into our legal order. And the European Withdrawal Act, the EU Withdrawal Act, does that through a variety of means of sort of retaining that and turning it into national law. And it also creates powers for government ministers to make necessary or to make amendments to that existing law where it might be required for it to make sense and to work once we're no longer part of the European Union. Now, there was a lot of concern as this legislation was going through. There was a lot of activity, particularly civil society organisations, working together to try and try minimise some of the effects of this legislation that we saw as particularly problematic from perspective of respect for rights, respect for democracy. And so there were concerns about the extent of powers that ministers had to be able to change primary law. They could make these changes. And so these Henry VIII powers, they were called. So attempts to try and put controls on how and when they could be used. And also attempts to get some sort of human rights protections introduced or secured within this body of legislation. And in some respects, we've had some improvements, and in others, the aims of those groups that were trying to push forward on making us a better piece of legislation hadn't gone quite as far as had been hoped. Where we do see a particular movement, where the legislation really did shift 180, not 360, that would bring us back, wouldn't it? Yes. So where it did sort of shift quite considerably is in relation to how it handles devolution and what it does about the relationship between Westminster and the devolveds. So the initial starting point was one that essentially saw things default to Westminster. So we've had this, as we say, 20-odd years now of devolution, and legislation that sets out in these policy areas, responsibility, first and foremost, lies in Scotland or in Wales or in Northern Ireland. So things like the environment, things like agriculture, education, health, these are devolved areas. Now, where the EU has responsibility and has a role to play, we can see that that responsibility is shared between the EU, the UK, and the devolved level. Now, the UK government is particularly concerned that if we bring these powers back from Brussels, bring them back from the EU, and then disperse them, follow the devolution legislation, let Wales, let Scotland, let Northern Ireland set their own agricultural policy, set their own fisheries policy, their own environmental policy, without the common framework that EU law provided, that we might then have quite an unruly, unwieldy system that might be problematic from the perspective of signing up to common trade deals, that might have concerns for the UK internal market. The answer is, that's devolution. So there are concerns about that, and the starting point was, okay, well, we'll bring all these things back to Westminster, and then we'll decide whether or not we can allow them to sort of flow back to Wales and to Scotland and to Northern Ireland and to follow the existing devolution legislation. So that was the starting point, and understandably enough, that didn't go down very well in the capitals of Scotland, Wales, and Northern Ireland. And there had been a sustained and very effective campaign, particularly you see the Scottish and Welsh governments and the institutions here, the various committees, playing a very, very active role in seeking to amend that approach. Ideally, the perspective was, let's just get rid of that entirely. We don't need anything that constrains the devolved competences. We just take this out completely, those sorts of restrictions. We've not got that far. The legislation doesn't do that. There are still the possibilities of restraint and constraints, but the default shifts. The starting point is, in principle, we respect the devolution legislation and powers return to where the Government of Wales Act says they are, where the Scotland Act says they are. That is the starting point. But it's recognised that some common working will be necessary, that it makes sense to work together in relation to animal health, in relation to various aspects of environmental protection. So that there's an interest in having common rules and work together to make those rules. So what we have now is a provision in the Withdrawal Act, Section 12. It's been Clause 11, Clause 15, now it's... So it's a situation now where powers are returned, but there is a provision in the legislation that allows UK ministers to adopt regulations to basically freeze what we already have and to say no one can change this existing law. We're going to freeze it until such a point as we can together, the ideal, we can together create our new common rules on cultivation of GM, new systems for agricultural supports, for funding farming, so critical here in Wales, for farming, for the broader communities, for language communities, to have those sorts of issues dealt with that have a local dimension, but also we might want to work within a broader UK-wide framework. So this provision now of a freeze for a UK ministerial regulation and then looking ahead to new rules. Those provisions come with safeguards. That initial freeze, there's a time limit. That the UK government has 2 years from exit day, which we're taking to be the end of March next year, 2 years to use that freeze power. And then there is a period of 5 years during which the new rules are to be adopted. And if they've not been adopted in that time, then it's thawed out and the power comes back and can be exercised here without any restraint or restriction. So there's that time limit safeguard. The other safeguard built into this is that there is a requirement that there is consent given here to the use of those regulations. Now, it talks about giving consent. It is possible for UK Parliament to go ahead anyway, that it's not absolute consent. But if the Welsh Parliament, or the Welsh Assembly, or the Scottish Parliament choose not to give their consent, the Westminster Parliament will hear why that is the case. So there are certain safeguards. There's an upgrading of the sorts of protections that we usually see. And although for some this does not go far enough, this does not satisfy the devolution ambitions or does not seem to reflect where we are in devolution terms, we need to recognise just how much of a distance has been travelled from those initial proposals. So what we've seen, this legislation has come in. We've started to see the first regulations to be made under it. Some aspects will be triggered later within the withdrawal bill. But it's one piece. It's a key piece, but it's only one piece of the legislative measures that are going to be needed to get the UK ready internally, whatever happens externally. So that's the Withdrawal Act. What you'll have heard a lot about in the last few days, what's been going on in the House of Commons, has been around these first two pieces of other legislation. So that's the Taxation Cross-Border Trade Bill, also known as the Customs Bill, and the Trade Bill. Now, those two bits basically get us ready, roll over those relationships that we've already got with other countries through our membership of the EU. Rachel made reference to the EU's new trade deal with Japan. That's just one of a number of trade deals that the EU has and that the UK participates in through its EU membership. So we need to make provision domestically within the UK and there's been agreement that we will roll those over. The intention is that they will be continued, and we will continue to be, at least for the transition period, for a period of years, treated as though we are an EU member state as far as those international trade deals are concerned. And so the cross-border trade bill, there's one that deals with sort of tariff barriers, so the financial bits, the duties that are collected when goods cross borders. And then the trade bill is more about the non-tariff barriers, so rules in international agreements about different regulatory standards and how we bring those things together. So that's currently been sort of kicking its way through the House of Commons. What we'll also see, but what these things will need to happen, but we haven't seen them yet, is a migration bill. What do we do about citizens and citizens' rights? How do we turn that on within the UK? We've also been waiting for some time now for agriculture and fisheries bills. So these are all sort of essential parts of preparing things for withdrawal. And there will need to be a piece of legislation that deals with, assuming we do get an agreement, the withdrawal agreement. And what that might require us is to then sort of suspend various bits of the Withdrawal Act, or just make amendments to various bits of the Withdrawal Act that won't work depending on what we agree in the Withdrawal Act. So there we go. So that's Westminster legislation. That's what's been going on there, what we've got, what we've achieved, what's been secured, and what is still sort of bubbling along. Now, with that legislation, when Westminster is legislating, when the House of Lords, House of Commons are together making legislation, what role does this institution have? What role does the Welsh Assembly have? What role does the Scottish Parliament have? Well, there is a convention. There's an accepted practice that in those areas, if it's a devolved area, if it's to deal with a devolved matter, that Westminster Parliament has to get the consent of these institutions. That they will not normally legislate on devolved matters without the consent of the Welsh Assembly or with the Scottish Parliament. And this is known as the Sewell Convention, after an official that was responsible at that time in Scotland. So Westminster will not normally legislate. It's been written into legislation, but what we've seen is that you can't go to a court to enforce it. This is the nature of our constitution, is that it's recognised as a political constitutional convention that cannot be enforced before courts. It is to be given effect to in the political domain. But it's a central and critical part of how we order responsibilities, powers, how the relationship between the different parts of the UK operates. And what we've seen is quite concerning and quite worrying from the perspective of the Sewell Convention and the relationship between the different levels of government within the UK. Because with the Withdrawal Act, the UK government recognised that it would need to come and get the consent from Wales and from Scotland for this piece of legislation. They acknowledged that they were going to do that. And ultimately, Wales, the Welsh Assembly, was able to do that. They felt that they had sufficient safeguards in the Withdrawal Act now to say, yes, we can accept this. There was an intergovernmental agreement that was reached back in April, 24th of April. I know that. It's my anniversary. I shouldn't forget that. It's how we celebrated. So an intergovernmental agreement between the UK government, the Welsh government, about how they were going to proceed, what they were going to do. Scotland couldn't sign up. Scottish government did not feel that they were able to sign up to that intergovernmental agreement, and they were not satisfied, not yet satisfied, with the safeguards that were in place for their devolved powers. They're saying this is not, any consent has got to be absolute consent. We've got to be able to block things. It's not enough to say you can override our refusal to accept. It has to be an absolute consent rule. So the Scottish Parliament has not given, and explicitly did not give, its consent to the Withdrawal Act, and it went ahead anyway. Now, where that leaves us, as I say, it's not something that can be enforced legally. Sewell, it operates where things are normal, not normally, and now there's an angle, well, this just isn't normal. Yes, but UK Gov said, they came out and they asked for legislative consent. It's concerning. It reveals a certain sort of fragility in that. We know that it's not legally enforceable before courts. Now we need to see what the political fallout is. It's going to play out politically in terms of what happens next. So in terms of what is the status of Sewell, we need to wait and see. We need to wait and see what happens. One of the things that we've got, or you could say is in the bag, is what might happen, is that the various bits of the Withdrawal Act, certain aspects of the Withdrawal Act, can be sort of cut off for Scotland and removed, and Scotland can operate its own Withdrawal Act. Okay? And this is what we've seen with the continuity legislation. So both Wales and Scotland, earlier this year, at a time when there was particular concerns about what the Withdrawal Act was proposing to do, decided, right, well, let's try and sidestep that. Let's create our own Withdrawal Act, get in quick, turn the EU law that is in devolved areas into Welsh law, into Scottish law, and then you leave it. It's ours then. Okay? So they were going to sort of try and sidestep the Withdrawal Act and the damaging consequences they saw from that for devolution. Now, the Withdrawal Act itself has come quite a distance since these pieces of legislation were introduced. Wales's legislation has received royal assent. It has a piece of legislation, the Wales Act 2018, the law derived from the European Union. The Scottish legislation has not yet, it's been passed by the Scottish Parliament, but it is currently before the Supreme Court, or there will be a hearing next week, Tuesday, Wednesday next week, where it's being challenged whether or not Scotland could actually do this. Now, the reason they're not challenging the Welsh legislation is because part of the agreement that the Welsh government made with the UK government to accept what was in the withdrawal bill was essentially, well, we're not going to proceed with our legislation. We don't need this anymore. And so the process has now started for it to be repealed and taken off the books. And so the Welsh legislation isn't being challenged because there's an understanding that it's sort of taking itself away. But the Scottish legislation, we've said, it is. Now, both the Welsh and the Scottish legislations, we said, in slightly different ways, but seek to do two things. Two things? More than two things. So they want the Welsh and the Scottish ministers themselves to be able to retain and restate EU law in areas of devolved competence, so in the areas of the environment and agriculture and fisheries, and to be able to make amendments to that law that might be necessary. A provision that we didn't see in the UK legislation, but that we see here, to be able to keep up with EU developments, to be able to introduce those, a keeping up power that we can sort of update the statute book in line of what's happening in Brussels. And then if UK ministers are going to try and make any laws within devolved areas, that the legislation seeks to put an obligation on them to wait for consent. So that's what the continuity legislation does. As we say, the Welsh Act currently being repealed, the Scottish Act, the Scottish Bill is being challenged, the Supreme Court hearing next week. If you look at you can go on the Supreme Court website, and you'll see there sort of the different parties yesterday set out, all 3 out of the 4 of them have set out their cases. The government still hasn't put its case out yet, unless it's there this morning. But we've got the Scottish government side of things, we've got the Northern Irish intervention, and also we've got an intervention from the Council General in Wales to say that although they are not sort of parties to the case, it's still in Wales's interests to have its voice heard in this process. And there's going to be some key questions being asked that are going to be important for Wales and Welsh powers. And so there's some of the things that are on what the court's going to have to grapple with. Essentially, the government is saying, the UK government is saying, Scotland just didn't have the power to do this. It was outside their competence. That it relates to a reserved matter. That it relates to, it's one of those areas that is just a sort of a UK government matter and nothing to do with the devolved. They're saying it's about international relations. It's about relationship with the EU. That there's no powers to act in an area that, although it's been devolved, that if there's EU law in that area, that it's not really devolved. So there's a variety of interpretations that are possible around that. And that legislating now is incompatible with our current obligations to give effect to EU law. That argument reads across, well, that's what the UK is doing with the Withdrawal Act. You know, it doesn't work. So we need to wait and see. They do make some, you know, the actual grounds for challenge are sort of very, very narrow in terms of what's possible under the legislation, what grounds you can use to challenge the legislation. And one of the broader points that needs to be addressed is what is broader issues, rule of law type issues. Can they be used as a ground to challenge the legislation now? And that's going to be tested as well. Or is it only what's set out in the legislation? Okay. Looking to the future, wherever we may be, once we do leave the European Union, as things are running, March 2019 is exit date, but assuming we do have agreement that transition will go on for 2 years, so things stay exactly the same, but for the fact that we've got nobody in the institutions, unless we agree something else. So things stay the same, and then things open up here. You know, we don't know what new international trade deals we may have with other countries. We don't know what commitments that might generate for us. We don't know what impact that might have on our ability to, you know, to deal with things like GMO, genetically modified organisms, and how, you know, we regulate something like that. What we know is that there's this push by the UK government to say that we're going to need common frameworks, we're going to need to work together. And it's identified that we're going to need those, particularly for the UK, for the existence of this UK internal market, so that people and products can move freely around the UK. That there's also, you know, if we look at sort of the environment, that it might make sense from the management of common resources, from rivers, and, you know, things that are shared resources, that we work together. And I think everybody can sign up to that and agree and accept that. But the issues are, how is that done? And what role, what voice, what say do the devolved assemblies, parliaments and governments have in the making of those common frameworks? And so we've got some work going on between the governments on setting out some principles for common future working. But it's not enough, and it's not enough yet, and it doesn't bring us the sorts of guarantees and protections that we might want to see from the perspective of devolved institutions that work within this system. And just to flag up as well, there we go, last one. You know, how will these frameworks be made? What kind of role for stakeholder involvement will there be in making these frameworks? What role for the Assembly? How much space for local variation will there be? And more generally, this idea of a UK single or an internal market, we need to be sort of conscious of this because of the challenge it could bring to devolution, and to be ready to sort of respond to that and say that, you know, a single market, internal market, as we've seen with the EU, does not mean that everything has to be the same. It doesn't mean it has to have just one set of rules for everyone, that there is some space for variation within that. Okay? Okay. Right. That's me done.